Okay, this is what you can and can't do. This is where you get your this is their ultimate delegation of authority, and they're trying to figure out some way all the time to circumvent this, and they have. And how they've done it is they're getting you caught up in these things right here, contract law. Now, corporations also operate privately also, and can be a person with rights. Matter of fact, when you read administrative law, you will find out, you'll see there are many times it will say that the United States can create a right. The United States can create a right.
Administrative law, American jurisprudence. Section 2. Concern with private and public rights. Sometimes the language of private rights is used in the administrative context. However, this language may simply signify a policy relevant to administrative law encompassing both public and private rights. Because administrative agencies serve in part to effectuate the constitutional obligation of the executive branch to see that the laws are faithfully executed, the public interest is an added dimension in every administrative proceeding. In addition, the public rights doctrine impacts administrative agencies. In certain areas, the principle applies that particular administrative agencies are created to protect the public interest and not to vindicate private rights. Sometimes the distinction is made between legal rights and duties enforced through the administrative process and those left to enforcement on private initiative through the legal system. In essence, the public rights doctrine reflects simply a pragmatic understanding that when Congress selects a quasi-judicial or administrative method of resolving matters that could be conclusively determined by the executive and legislative branches, the danger of encroaching on the judicial powers is less than when private rights, which are normally within the purview of the judiciary, are regulated as an initial matter to administrative adjudication. Where private common law rights are at stake, the court's examination of the congressional attempt to control the manner in which those rights are adjudicated will be searching. However, Congress may create a private right that is so closely integrated with a public regulatory scheme as to be a matter for agency resolution with limited involvement by the federal judiciary. These separation of power concerns are diminished when parties are not required to, but merely have the option of proceeding in an administrative form. When an agency refuses to act, it generally does not exercise its coercive power over an individual's liberty or property rights, and thus does not infringe upon areas that courts are often called upon to protect.
Well, to understand what that's talking about, the first thing you have to understand is the United States in 1871 became a corporation, all right, operating under the guise of the de facto government. Obama is the president of a corporation, not of a country, all right? And what they did, that's because the United States is in bankruptcy, all right? So they're operating a position of receivership. So what happens is, what they have done to keep it going, is that they have gotten everyone into contracts. They formed a corporation and then issued out contracts. If you look in the Constitution, it says that the United States is only 10 miles square in Washington, D.C. How they got outside of that is they contracted with you. And that came in the form of birth certificates, driver's license, social security cards. When you go get your driver's license, they put about 50 times on the application, are you a U.S. citizen? Go to the driver's license and go look and see. Okay, are you a U.S. citizen? Well, U.S. citizen means are you a citizen of this corporation? Now, since you contracted with this particular corporation, now you fall under their rules and regulations. Now they have a right to establish rules and regulations that you can abide by. Now they have usurped your authority, and now you're under their authority. That's why when you come into the courtroom, first they want to know is you a U.S. citizen. All this. And now how they're trying to fool the sovereign citizens. Now you come in court, they say, well, you're one of those sovereign citizens. There is no such word as sovereign citizen in any law book, okay? They changed the word sovereign from a noun into an adjective. You know, you're a sovereign citizen, like a type of citizen. You know, and that's an oxymoron, all right? So when they come in there and they you know, they're very tricky. They come in and they say, well, you know, you're one of those sovereign citizens coming in my courtroom. Well, you know, and some people respond, well, yeah. Well, he's automatically got you into something because there's nothing in law that will protect a sovereign citizen. There's something in law that will protect the sovereign.
Georgetown University Law Center. The People of the State, Chisholm versus Georgia and Popular Sovereignty by Randy E. Barnett. Chisholm versus Georgia was the first great constitutional case decided by the Supreme Court. In Chisholm, the court addressed a fundamental question: who is sovereign, the people or the state? It adopted an individual concept of popular sovereignty rather than the modern view that limits popular sovereignty to collective or democratic self-government. It denied that the state of Georgia was a sovereign entitled, like the King of England, to assert immunity from a lawsuit brought by a private citizen. Despite all this, Chisholm is not among the canon of cases that all law students are taught. Why not? In this essay, I offer several reasons. Constitutional law is taught by doctrine rather than chronologically. Law professors have reason to privilege the martial court, and the court's individualist view of popular sovereignty is taught to have been repudiated by the adoption of the 11th Amendment. I explain why the 11th Amendment did not repudiate the view of sovereignty expressed in Chisholm by comparing the wording of the 11th with that of the 9th Amendment. I conclude by suggesting another reason why Chisholm is not in the canon. Law professors follow the lead of the Supreme Court. And, like the 9th Amendment, the Supreme Court has deemed its first great decision too radical in its implication. Now, what is really interesting that in looking for this particular document, I ran across a website that talked about the first case. I put in, I was looking for a case, the first case of the Supreme Court. And I came across the History Channel. And just to go in on what he's saying, when you look around, you're going to see that they will not tell you about the Chisholm versus Georgia case. They always refer to the Marshall case. And it is not the first case, Chisholm versus Georgia. But they had a plan, and you can see right here in this history, and it'll tell you, early days of the Supreme Court. The Supreme Court was established in 1789 by Article 3 of the U.S. Constitution, which also granted Congress the power to create inferior federal courts. The Constitution permitted Congress to decide the organization of the Supreme Court, and the legislative branch first exercised this power with the Judiciary Act of 1789, which all this is incorrect as well, because the Supreme Court, they're talking about the Constitution organized the Supreme Court. The Judiciary Act, because of separation of powers, it doesn't have any effect over Article 3. This is talking about the U.S. Supreme Court and the federal judiciary, not the justices that are Article 3 judges. And it's talking about the act signed into law by President George Washington The act signed into law by President George Washington specified that the court, with a small c, would be made up of 6 justices who would serve on the court until they died or retired. The Supreme Court, now this is in the act, all right? Now, the Supreme Court was first assembled on February 1st, 1790 at the Merchants Exchange Building in New York City. But due to some justices' transportation issues, the meeting had to be postponed until the next day. Though the court had its first meeting on February 2nd, 1790, it didn't actually hear any cases in its first term. The court's early meetings were concentrated on working out organizational procedures. The 6 justices handed down their first decision on August 3rd, 1791, just one day after the court heard arguments for the case with West versus Barnes, an unremarkable case involving financial dispute between a farmer and a family who owed debt too. Now, we can see also that this couldn't be talking about the Supreme Court of the United States of America. This is the U.S. Supreme Court that was established by the Judiciary Act as well. And we can see that this was not the first case, so it couldn't be talking about the Supreme Court of the United States, because the first decision of the Supreme Court of the United States was Chisholm versus Georgia. People start paying attention. These people are fooling you. Pay attention.
But now the sovereign citizen. So you got to identify what your status is, and that's what we have right here, status law. Now, how it works is this. They don't know what your status is unless you tell them.
We talked about this with Monty. You in there blindly walking around, they're gonna make decisions for you if you don't tell them what to do.
They operate primarily off of what's called presumptions, assumptions, and color of law. Now, when you're in a courtroom, the judge, he'll speak in a kind of way that, like, it's kind of authoritative. You know, he'll say, so Mr. Jones, sit down, you know, something like that. You know, they got a little different techniques. Some of them try to be nice. Some of them try to be mean. They got all these different techniques they try to use. But you ought to know it's all toonland. They're cartoons, fictions of law. And what they'll do is they'll make a statement, and it's authoritative. But what you have to realize is that anything that's coming out of their mouth, whether it's the prosecutor or the judge, it's a presumption. They're just presuming things. It doesn't matter how they say it. They can say it however they want to. They can express it any kind of way. They can be but it's an assumption. You know why? Because in the court, you have to be sworn in. Because anybody who's in court is testifying. Anything you say can and will be used against you. Doesn't say might, it says will.